Warning: this video is not a complete analysis and does not include every error, nor does this substitute for legal counsel.
Oh, shit. Here we go again.
Oh, no.
Judge Jeremy Baker was sworn in as the new Valdosta Municipal Court Judge, replacing the late Judge Vernita Lee Bender.
It's an honor. That's the biggest thing. It's an honor to serve the community in this capacity. It's an honor that the city councilor and mayor had trust in me to be able to do this job. And it's an honor for, to be in a position to hopefully make a difference and to be a role model.
The graduate of Lowndes High School is proud to serve the community that he grew up in. He says this new opportunity gives him the chance to give back to his hometown.
All the support that I received throughout my formative years, my previous legal experience, from my parents to my mentors to Judge Bender. To fast forward, what it means is I want to be able to give back to what I received. I was given a lot of support and a lot of guidance, so I want to be able to pay it forward to those young men and women within the community.
He wants to live up to the legacy that Judge Bender left behind, both in the community and on the bench.
While she was on the bench, she served with integrity, compassion, and just open-mindedness. She set such a solid foundation to serve and for the community, whether it was on the bench or off the bench. And when I decided to apply for this position, I used her as my example of how to be a judge for this court. Just because, how she conducted herself, like I said, on the bench or off the bench, just was an example for everyone.
The father of four spends his free time being involved with his church and camping with his kids.
I have 4 young kids at home, and so when I'm not working, all of my time is with those kids and my wife. We are huge campers, tent campers. So if any opportunity I have, when I'm not at work or I have some vacation time or some free time, me and the kids and my wife and family, we enjoy camping. That's kind of our thing, our get away from technology and just kind of spending time together. All of my kids attend St. John's Catholic school. My wife teaches Sunday school, so we are heavily involved in the St. John's community. So when I'm not at work, is usually I'm doing something with the St. John's community.
We welcome Judge Baker to the city and look forward to him doing great things for the community.
Oh shit, here we go again.
Meet Bradfield M. Sheely, the district attorney for the Southern Judicial Circus. Here, we see Jeremy Baker and Brad Sheely throwing irrelevant material at the jury to get a conviction for a self-defense case of a man with a carry permit, defending his friend's life, first, then both of their lives, after another charged at both of them.
I think it's unfair, but this is the justice system. I'm assuming this is where it's supposed to be.
District Attorney Brad Sheely says Denson's release was a result of a granted motion for a new trial and him meeting bond.
It doesn't happen often, but it can be done under the law.
Sheely says the law allows a superior court judge to act as a 13th juror.
The judge found, in his opinion, that the verdict was against the weight of the evidence.
Sheely says that his office is appealing to the Georgia Supreme Court the decision to give Denson a new trial.
The price is wrong, bitch.
Oh shit, here we go again.
Here, we see a pointless clown show that had no business in the appeals court. The Clowns County Sheriff's Office, and other anonymous clown tipsters, Brittney Lee Coons-Long, a Southern Judicial Circus clown public pretender defender and ass's tainted district attorney, Jeremy Baker, did no background research on the defendant, nor case law research concerning the defendant, before deciding to dig in your pocket, for no reason. This case involves a defendant on probation, which means there is no expected rights to privacy, while being supervised. However, we see the clown show commence, all to point out that cops can dig into your pockets to get the first warrant. That is not necessary, just to get a second warrant, for a defendant, on probation, show up to his doorstep with a clown's dog, because some mystery clown says a black man is there and is suspected of narcotics activity, a clown's dog, with no actual recorded evidence of hitting on anything, and then use that to get full access inside his home? Thanks, Jeremy Baker, and clowns. Domestic enemy much? Oh, wait, we're not finished.
You know, me and the kids and my wife and family, we enjoy camping.
No, 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 no.
Dedication to justice? Ha 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 ha. Before his entry, as judge, from an untimely death, Baker was coaxed by the DOJ to go unconstitutionally aggressive on your pockets in especially firearms cases, as you'll witness next.
No, 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 no.
I believe in the commitment to just us, clowns, outside of the law. Serving in both public and in private practice as an associate with Clown Man Folly Law Firm, I understand the impact of a superior court judge. I have witnessed how the law could be used to manipulate and extract from our communities. I have a commitment to serve just us, clowns. I know that integrity is not a pillar of our justice system. I know the importance of a judge holding steadfast to the principles of having zero temperament, zero patience, zero humility, zero tact, indecisiveness, closed-mindedness, and zero common sense, and with my public, private, and just us experience, I have the commitment. Mr. Watson was selling drugs.
Wrong, Jeremy Baker, that is a misstatement of the facts, as Mr. Watson was illegally charged with alleged constructive possession with intent to distribute cocaine, and nowhere on any record was it proven that Mr. Watson was selling cocaine.
Here, Lieutenant Robert Picciotti /FBI agent is lying to the jury about a fictional officer who supposedly killed himself after not providing any evidence to verify that Mr. Watson was selling drugs out of his quote home, car, and out of water bottles. There's no Prine record of any of this. All of this is fabricated evidence after the illegal entry.
Preliminary expert witness report and opinion. I am a police practices expert and retired undercover detective. I was contacted by Alan Watson regarding a request that I review evidence and information related to his arrest for drug sales and weapons charges. I have reviewed the evidence listed below. Evidence reviewed: police reports, court records, audio recordings, witness statements, opinions, and conclusions. After reviewing the arrest report and other related materials, it is my opinion to a reasonable degree of professional certainty that Mr. Watson's arrest is based on an improper search and seizure. Mr. Watson's girlfriend, whose home was raided, was coerced into allowing a search of her apartment, leading to the seizure of evidence that serves as the basis for criminal charges against Mr. Watson. It is my opinion that the search should not have been conducted without a warrant and that Mr. Watson's girlfriend was improperly detained, though there was no evidence she had committed any crimes. I have reviewed the evidence provided by Mr. Watson for the purpose of rendering of opinion regarding the conduct of the officers who contacted him and regarding the search of his girlfriend's residence. It is my opinion to a reasonable degree of professional certainty that the police did not follow policies consistent with my training as a police officer with regard to the search of Mr. Watson's girlfriend's residence and with regard to the use of a traffic stop of Mr. Watson as a pretext for a search of his former employer's business. The search of Mr. Watson's girlfriend's home appears to be inconsistent with my training as a police officer. The officers appeared to use coercion to gain access to the residence, and it appears that they used the fruits of a bad search against Mr. Watson, though there appears to be no connection to Mr. Watson and any of the items identified as evidence of a crime recovered by the police. With regard to Mr. Watson's complaint that the police have engaged in a pattern of harassment, his charge has merit. It appears that the police have targeted Mr. Watson with investigative contact searches and traffic stops that appear to be unwarranted and contradicted by the evidence reviewed for this report. Opinion: we have conducted a comprehensive review of Mr. Watson's case. The review included several hours of interviews, a review of police reports. We believe that the evidence we reviewed supports Mr. Watson's claim that he was profiled and that he was the target of improper police conduct.
Now, don't feel sorry for Mr. Watson because he chose to represent himself.
Another misstatement of the facts. Mr. Watson was appointed counsel for the trial, Wade Krueger, and before trial, Mary Lynn Paulson and Brittney Coons-Long, who are on record trying to convince him that the prosecution is justified and acting as if they are not required to communicate what would be filed on his behalf, all after a psychiatric evaluation was filed to be done, without telling him anything, nor having any legitimate basis to do so, so they were fired. Mr. Watson also hired an attorney, Byron Watson, who claimed the case would be dismissed, then withdrew, leaving Mr. Watson with his own motion to suppress and no attorney. Mr. Watson's motion to suppress was denied by Judge Hardy, then handed to him at trial by Chief Judge Richard Cowart, illegally, beyond Georgia Code Section 156-21, for ruling on motions in 90 days in Lowndes County, Georgia, with a population of over 100,000 and denying him any appeal before trial. Oh, and let's not forget that he said, on record, that he wanted to send Mr. Watson to prison, which is the highest form of error, called a superplane error. Then, he sentenced Mr. Watson, illegally, under a recidivist statute that does not apply to Mr. Watson, yet was sinisterly pursued by Jeremy Baker and supported by Brad Shealy and Robert Picciotti at sentencing, ignoring the pre-sentencing investigation recommendations, and even going as far as threatening Mr. Watson at the trial with the prosecution for his free speech on social media.
Mr. Watson made that decision. Just like Mr. Watson chose to sell drugs. Just like Mr. Watson chose to intimidate other people, Heather Pearson. Excuse me, Ms. Pearson Price. And just like Mr. Watson chose to bully his father into testifying for him, he made those decisions.
Hi, I'm Heather Price. Interview right now about what happened on my end when the Lowndes County Sheriff's Department came here. So I was sitting at home eating dinner. I got home a little bit late. I had been trying to contact my fiance Alan Watson and was not getting any response. Little did I know he was already in handcuffs. So I was sitting in my living room right here in this chair when I saw two officers walk past the window. So immediately I thought that Alan had been in a car accident. So I was like really nervous when I answered the door because I thought that he had been hurt. So I answered the door and I stood right here. And when I came out the door, I saw there was more than two officers.
They knocked on the door, and when I opened the door, there were two officers standing at the doorway. There were multiple officers standing behind them with, what I would say, a fleet of black SUVs. They were definitely showing force.
Right back here, there were two, maybe three vehicles, if not more. There were officers everywhere. I did not count the specific number, but it felt like there was at least 10. I was asked who I was, and I told them my name. I asked if Alan Watson was my fiance and if he lived here. I said that he goes back and forth between here and his father's house. That's on Snake Nation Road. And then I asked, why were they here? The head officer wanted to come inside, and I immediately told him no. He said that he would like to search the premises, and I said that I would like to exercise my Fourth Amendment right and that I wanted a warrant. He then further pressed on about still wanting to come in, and I told him no, but that I wanted to know what happened. He wanted to come inside to tell me what happened. I told him no, that I would step out to talk to him. So I took one step out. He was standing approximately here. There was another officer here. All the other officers were out in the yard, in the parking lot. So he proceeded to tell me that Alan had been arrested for possession of multiple guns and ammunition. They told me this several times, and it wasn't just him, it was him and another officer that told me It was multiple guns and ammunition. And basically that he was trying to say that Alan was telling them that all that was mine. So they were kind of trying to get me worked up and like basically trying to make me mad at Alan. So when I told him that I wanted a warrant, I went to step back in. There was an officer standing right here. He stuck out his arm like this and said, "No, you will have to wait out here while we get the warrant. It'll be about 2 hours."
Consent product of illegal detention. Black versus State, Smith versus State, Walker versus State, State versus Woods. Consent must be uncoerced. Williams versus State, State versus Fulgham, State versus Williams, Darden versus State. Mere acquiescence to authority of officer did not substitute for free and voluntary consent. Hollenbach versus State. Consent by roommate did not authorize search. Preston versus State.
So at this point, I notice when I look back, you can see through that back window back there, there was officers in the backyard. So they had begun, as soon as I said no, I needed a warrant, they needed a warrant, they began to circle the premises. They all got on their little radios, they're all doing their thing. It became very evident to me that these guys did not just come here just to leave, they were going to come in either way. And I did not want to stand out here with them for 2 hours, I had other things to do. So, and it was brought up in preliminary that I did refuse the search at first, and that then afterwards I granted them permission. That was after they were basically detaining me outside, that I could not go back in. Why I was being detained, I don't know. I was under no suspicion that I know of. I should not have been because I did no wrong. So that's why I granted permission. Now another officer went to a vehicle, grabbed a clipboard, basically had a so-called, grant to search. That's all in the
consent form.
The consent form that's in the evidence
for the vehicle.
It said for a vehicle, which they crossed it out and wrote my address. So I signed it, and then they all came in.
Oh shit, here we go again.
The level of incompetence is staggering and scary, to say the least. Wade Krueger is appealing without knowing what he's appealing, a waste of taxpayer money and the higher court's time. More incompetence with an appeal without merit. Three strikes and you're out in baseball, but as a public pretender with incompetence, how many licks does it take to get to the center of a Tootsie Pop? 2020 Georgia Code Title 17, Criminal Procedure Chapter 8, Trial Article 1, General Provisions, Recordation of Testimony in Felony Cases, Entering Testimony
on minutes of court where guilty verdict found, preparation of transcript where death sentence imposed, preparation of transcript where mistrial results in felony case.
On the trial of all felonies, the presiding judge shall have the testimony taken down, and, when directed by the judge, the court reporter shall exactly and truly record or take stenographic notes of the testimony and proceedings in the case, except the argument of counsel.
Except the argument of counsel. Accept the argument of counsel.
Accept the argument of counsel. Accept the argument of counsel. Accept the argument of counsel.
Accept the argument of counsel. Accept the argument of counsel. Accept the argument of counsel. Accept the argument of counsel. The state of Georgia wants to make sure you get convicted with as little accountability to the conviction as possible. The closing argument of counsel has evolved into becoming important only in cases seeking the death penalty. However, prejudicial closing arguments let alone with misstatements of facts, are not tolerated in any district court in the United States of America. Yet still, the United States of America has more people incarcerated per capita than any other nation on earth, with the state of Georgia having more people incarcerated or on supervision than any state in the entire world. The title town of football? How about the title town of slavery? If slavery ever migrated somewhere, it's here, within these loopholes, with quote freed blacks and other moronic Nazis pushing every bit of it.
Here's a scumbag Georgia attorney who can't resist lying to the jury, even in a death penalty case. Wow, where do these demons come from? Now, here's a Bible-thumping attorney, getting a case reversed because he urged the jury to go with the Bible, instead of Georgia law. Notice that these cases are death penalty cases.
Finally, we see Wade Krueger compelling the jury to believe that entry into his father's car by the Lowndes County Sheriff's Department, without legal consent, nor valid legal basis to do so, can be made legal, along with, Ms. Price cannot be trusted and does not deserve to have her Fourth Amendment rights protected, therefore must be hiding something. This video is brought to you in part by Elizabeth Gallo reporting. Also, don't forget to subscribe to Acon for a While's channel. Thanks and enjoy the circus.